were not his own, but rather they should be split in wife and husband, and so on and so on, and under the provisions of Russian legislation, all court orders should be declined, and okay, there should be no freezing order on our joint assets, joint Shalva and his wife. But Supreme Arbitrage Court declined her supervisory appeal. Of course, he said, made analysis the Russian legislation related to marriage and so on. But as a base, Supreme Arbitration Court indicated that, in fact, Russian Arbitration Court provides possibilities for the courts to support either national or international arbitration procedures by granting an interim relief in different ways: freezing orders, disclosure orders, and so on and so forth. So all possible interim measures that could be granted by Russian state courts based on Russian legislation. And after this case ended in 2013, just maybe in half a year, the Supreme Arbitrage Court issued, as I said before, this quite well-known presidium related to the disputes with foreign parties. And now, I think, even without the Supreme Arbitrage Court as a leading court for commercial disputes, we will continue to use such an effective mechanism that was provided for the parties involved in national or international arbitration, even in case we do not have a very straightforward and strict provisions in Russian Arbitrage Court that interim measures could be granted by a state court in support of arbitration, even having such an outdated law on international arbitration. But from a practitioner perspective, I think that at least the recent practice of our economic division of the Supreme Court show us that we still, at least in the field of interim measures in support of arbitration, follow these good positions that were provided by Supreme Court late in 2013, just before it disappeared next year. So I think, as a conclusion, I will repeat my initial words that you will be praised by your client, get an accolade when you will get an interim relief either at the national court or at the arbitration, because of the difficulties you met as a lawyer when trying to persuade the emergency arbitrator or a judge that interim relief should be granted in support of the client's expectations. So now questions and answers, and I will try maybe to allow you to pierce the veil of interim relief for our practice, or maybe to ask Katerina to help me with the answers.
Do you represent the client?
How much you risk? Not personally.
Other questions? What was the place of arbitration?
LCA. And LCA rules and London.
London.
Yeah.
So it was in support of a foreign army?
Yeah. It was in support of London arbitration.
Excuse me, have you heard of a precedent like that after the Chigrinsky case?
Not really in support, at least in support of international arbitration. But,
None in support of international arbitration.
yeah, but in support of national arbitration, we do had some 2 or 3 examples when we were granted with interim relief.
And excuse me, my second question is, you mentioned certain deficiencies of the present law on international arbitration that are a problem in obtaining an interim relief in Russian court. Can you please elaborate on that in a greater detail? What particularly you think is a deficiency that is a problem? Is it a deficiency about the Russian judges, or is it about the law, actually?
I think, in fact, the first issue, of course, these are Russian judges, and the law is only the second part of this problem. But as I said before, the law itself is quite outdated. So it was, the law was adopted in 1993, and since then we've already made some crucial changes in the model law on international arbitration. And to the date, even having some amendments in 2008, but as I said, they were quite small and only lift up the law rather than substitute it with something new and efficient. So we do have the problem, in fact, with the law on international arbitration, and I don't think either you know it or not, but earlier this year and last year I was participating in 2 quite big arbitration events when we were talking about the recent developments of Russian legal regulations related to the arbitration, either international or national. And what I should say now, that this initiative of Russian Ministry of Justice now was almost stopped by the Russian government, and at least I do not know the outcome of all proposals that were made recently for the last half year. But what I know is that starting from December 2015, I was never invited for the meetings related to the discussion of this draft. Before that, quite a large number of scholars and practitioners working at law firms or as in-house lawyers were invited and participated on quite high-level discussions related to the new laws on international and domestic arbitration in Russia. So I think that it might be due to the sanctions, it might be due to the overall economic situation, but we have what we have. We do not have even a draft to the date of the new law related to international or national arbitration regulation.
But answering your first question, I'm quite sure your former colleague Maxim Burkov was delivering a presentation about the other case.
Yeah.
There was one case. I think he claimed to represent some of that case. In that case, I don't remember the name, but I remember that in that case they managed to get interim relief first from Cyprus, from the Cyprus courts, and then quite similar relief from the Russian courts. That's why there was some confusion, because everybody, it was a huge class, and everybody was believing that our courts started to grant interim measures in support of foreign court proceedings, but in fact it was just the same measure which was previously requested from the courts of Cyprus.
Excuse me. And how it happens, how the body is to determine whether it's faster and easier to go to the state courts to ask for interim measures, or to go to the arbitration forum and do that. So or the party does it simultaneously.
In fact, it depends. For example, if we have an arbitration proceedings with a place of arbitration in common law jurisdiction, it's possible for the parties obtain interim relief faster from the arbitration. This is my approach. When we're talking about the Roman law countries, it might be easier and faster to get the interim relief from a state court. At least in Russia, it would be better and faster to file the application to a state court, rather, for example, to ICAC to get the interim relief. Because ICAC, of course, has the possibility to grant you with the interim relief, but I don't think, in fact, that yeah, it will follow this quite quite, let's say, quite a strange way for this institution. So this it's always a different legal system when we're talking about the possibility to enforce the arbitral award related to interim relief in common law jurisdictions, in commonwealths, at least when the place for arbitration is London or any other commonwealths. It would be better and easier to get the relief from the arbitration. Of course, when you agree for some emergency procedures, arbitration agreement in other cases, it might be easier and faster to get the interim relief from a state court. But of course, the main question is the question of enforceability.
Yeah, I agree that the question of responsibility for arbitrator decision might be crucial in this case, but in some cases, the client's case and the circumstances were just so that you have very little chances to get interim measures from a state court,
Yeah.
especially if it's Russian state court, which is extremely reluctant to grant any interim measures. But in that case, if you have no chances to get interim measures from the courts, you might consider trying to get in that from the tribunal, where you have more chances to get them, even taking the risk that it will not be enforceable,
Yeah.
and even taking the risk that the other party will not be compliant with this measure, but lose the credibility to comply with the other cases. And to continue this question, I was very curious when you said that the decision, well, the proposal, or the initiative whether to apply for interim measures or not should always come from business, come from the client. Because in my experience, it always comes from us.
Of course, when we're talking about the billing and legal fees, it might be the case, but I'm talking about, first of all, about business interests. Maybe it follow rather from Russian clients when they're asking to get quite fast court decision related to interim measures, rather from international or foreign clients that are used to follow the strategy proposed by the lawyers. Because, for example, what I know, what I see from my personal practice, is that each third Russian client believes that he is a lawyer, even being a businessman.
Oh, that it sounds like, well, everybody knows that. Some common knowledge.
Maybe it's simply different approaches.
Because in my experience, it's usually quite difficult at the beginning, at least, to persuade the client to spend extra money, spend extra time, get more troubles, but to go for this procedure, which is not 100% guaranteed.
Yeah.
And we have to persuade the client and say, look, you have your case, but at the end of the day, you might just have your word and put it on the wall.
Yep. I agree with this perspective.
Any other questions from the audience? Okay.
Excuse me, can we speak about the judges a little bit more, coming back to the issue of unavailability or pretty much unavailability of those provisional measures from the national court. What is the problem with the judges? As far as I'm concerned, there are at least two international instruments that say that a party to arbitration may go to a national court for interim relief. We have this law of 1993, we have, I don't know, 1995 or something, information letter from the Supreme Arbitration Court, we have the new information letter, we have the Chigrinsky case, we had some little practice before the Chigrinsky case and after the Chigrinsky. What is the problem with the judges? In 2013, like 2 years ago, a year and a half ago, the Supreme Arbitration Court once again said that there is no problem for a party to apply for provisional measures. So, if not taking into account this reluctancy of the judges to grant the provisional measures generally, what is the problem? Why not grant interim measures in support of an arbitration in Singapore or in London, in your opinion? And what should happen, like, how do we change this? Do I become a judge, or do we wait 20 years until the generations change what? Just like as a point of free discussion.
You know what? I will try to answer a question in the following way. Have you heard about the recent case, about the recent Gazprom case with some so-called pocket arbitration? Yeah, I think that for you it might be quite interesting to have a video translation of this court hearing. I in fact was not a participant, but the lawyers who were involved in this case, they just described the situation in the courtroom. I think you know the names. You know the names of the judges that were involved, and this particular judge who came from a former Supreme Arbitrage Court. I think that her last name is Pavlov, yes? Yeah. So I was said that she was just trying to ask as more questions as it possible to Gazprom. What's that, what this, and so on and so forth. Then, when she understood that everything is clear, she just sat on a chair, like, began to look in a corner, on a wall, not looking at the representatives, at the parties. So I think the main problem, in fact, is that we're still, I think overall, are trying to follow some very bad route of supporting some okay things that are legal, formally legal, but which do not reflect the development of the legal system and of the economic system. Maybe this is the main case in all cases, related not only to the arbitration, to the interim relief measures in support of arbitration, but in general to legal system. I think this is the main problem. So when you are a judge, you are trying to be independent, you are trying to be impartial, but when, at least in that particular case, Gazprom is saying, no, I'm claiming against myself, I'm ready to pay under the arbitral award granted by my pocket arbitral tribunal. And all judges just shaking their heads and saying, yeah, Gazprom is ready to pay, and it's good. Then maybe the pocket tribunals are not such bad as we were told before. Maybe they are very good. Yeah, maybe they're useful. So I think this could be an answer at your question. It's not in fact legally grounded, but it has ground in a very, how to say, a very bottom of all system in Russia.
And what do we do about that?
Just wait.
Because you mentioned this in Madam Justice Pavlova. I think a couple of years ago I heard her on a conference speaking about arbitration proceedings. She said that the justices in the Russian State Court, first of all, she proposed to form certain divisions, benches that will be specializing in arbitration support and recognition of awards. Secondly, she mentioned that justices like her should be more open to public, should participate in conferences more. And thirdly, she mentioned that they should study, that there should be some education centers and something for the justices.
I know her position very well, but you know what? When she came to Supreme Court, to the economic bench, not only her, in fact, but all judges were banned to participate in any kind of conference. Because, for example, we were waiting her to participate at least two conferences last year, and she was just prohibited to participate.
I'm sorry, I think the code of conduct for the judges, the president, it actually allows the judges to do so. So why would they ban?
It's not due to the code of conduct, it's only due to the position of Mr. Lebedev and, of course, the position of the head of economic division.
Yeah, so what I meant was actually not about the Madam Justice's position, but what do you generally think are the ways to like help things come better?
I think we should.
Yeah, of course. I'm sorry.
Yeah, in fact, I think that again we should follow the law. We should follow all information letters that were issued by the Supreme Arbitrage Court in Russia. We should be lawyers, and we should support our clients by finding way to improve the position, to find the evidences. This is, I think, in fact, the only thing we could do, being the lawyers, being the counsels for our clients. If we are talking about the situation from the other side, I simply don't know the short answer.
And a long answer can be proposed at the drinks.
Yeah.
Okay, so I propose, thank you very much, Stefan, and thank you very much, Katrina.